After the SBI testing had shown the presence of no DNA, Mr. Nifong arranged to take all of those evidence items that had been tested by the SBI and send them to a private laboratory called DNA Security, Inc. The purpose was to see if perhaps more sensitive DNA testing might reveal the presence of DNA on any of these evidence items. So that evidence was in fact sent to DSI. And on April the 10th, Mr. Nifong had a meeting with the lab director of DSI. He and Sergeant Gottlieb and Investigator Hyman drove to Burlington and sat down in a room with Dr. Meehan, Brian Meehan, who told them this: "Our testing has revealed the presence of DNA from several men. We don't know who those men are, but we do know that none of this DNA matches the profiles of any of the lacrosse players. So they are scientifically excluded as possible contributors of this DNA." On April the 17th, Mr. Nifong before April the 17th, Investigator Hyman talked with Mr. Nifong, who wanted him to go forward and obtain indictments against Mr. Seligman and Mr. Finnerty. Investigator Hyman expressed to Mr. Nifong his grave concerns about doing that, saying, "We don't even have any evidence he was at the party." Mr. Nifong instructed him to go forward nonetheless and obtain the indictments. Still concerned about this matter, Investigator Hyman went to his superiors and expressed his concern, and those superiors expressed that concern to Mr. Nifong, that there's no evidence about that Mr. Seligman was even present at the time of this alleged attack. Mr. Nifong said, "Go ahead, get the indictments anyway." So on April the 17th, Colin Finnerty and Reed Seligman were indicted for first-degree rape, first-degree kidnapping, first-degree rape, first-degree sexual offense, and kidnapping. 4 days later, on April the 21st, Mr. Nifong again met with Mr. Meehan. Mr. Nifong, Investigator Hyman, and Sergeant Gottlieb once again drove to Burlington and sat down with Brian Meehan. And at that meeting, Dr. Meehan once again explained that our testing has shown the presence of DNA from multiple men. We've done further testing since the last time we've met, and what we have determined is that some of the DNA that we found on the rape kit items belongs to Ms. Mangum's boyfriend. None of this DNA belongs to any of the lacrosse team members, except there's DNA on some false fingernails that were found in the trash can of Dave Evans' bathroom that had partial DNA profiles that were consistent with Mr. Evans and with another person who lived in that house. But on the rape kit items, there's DNA from several men, and none of them are lacrosse team members. One of the profiles matches the boyfriend. We've also got comparison samples from 2 other men with whom Ms. Mangum acknowledges having consensual sex in the approximate week leading up to this, and this DNA doesn't match any of them. This was told to Mr. Nifong in this meeting. Mr. Nifong said, "Well, I need you to prepare me a written report that contains the matches." So Dr. Meehan prepared a report. Now, preparing a report that contains the matches would only contain the fact that DNA from the rape kit was found on Ms. Mangum, matched Ms. Mangum's boyfriend, and that there was this DNA, these partial DNA profiles on the fingernails that were found in Mr. Evans' trash can that matched Mr. Evans and another member of the household. It would not reveal the presence of all this other DNA from men whose identities were unknown that had been found by the lab. Mr. Nifong indicated to Dr. Meehan that he needed this report for a court hearing that was coming up. On May the 12th, Sergeant Gottlieb, Investigator Hyman, and Mr. Nifong once again drove to Burlington and sat down with Dr. Meehan. Dr. Meehan went through this again. He explained that there is this DNA from multiple unidentified males on the rape kit items taken from Ms. Mangum. He provided the report. It was exactly the report that Mr. Nifong had requested. It reflected the matches only. It didn't reveal the presence of all this DNA from the unidentified men. Three days later, Mr. Nifong sought and obtained an indictment against David Evans for first-degree rape, first-degree sexual offense, and kidnapping. These 3 men are defendants in a very serious criminal trial at this point. They serve a lot of discovery requests on the prosecutor. They're looking for a lot of things, but 2 of the things they're looking for are reports of the conversations that happened between Mr. Nifong and Dr. Meehan at these meetings at DSI Security, and all of the results of any DNA testing done by DSI, regardless of what its findings were, all the testing. Mr. Nifong responded to some of these discovery requests and not to others, but he did not ever provide any information about the conversations he had had with Dr. Meehan at these meetings, and he didn't ever provide complete results of all the tests that DSI had performed. So the defendants filed a number of motions to compel, and they were still seeking that same information. Memorializations of the conversations with Dr. Meehan and all of the DSI test results. There was a hearing on June the 22nd. Judge Ronald Stevens was presiding. At that hearing, Mr. Nifong represented to the court that no discoverable information had been discussed at his meetings with Dr. Meehan, and that all communications with Dr. Meehan were privileged work product. Based upon that representation, not surprisingly, Judge Stevens did not enter an order specifically ordering Mr. Nifong to provide memorializations of his communications with Dr. Meehan, because of course he had said there weren't any other than the ones that are privileged. But the court did enter an order, and the court specifically ordered Mr. Nifong to provide to the defendants all witness statements, and all witness statements, any oral witness statements, were to be in recorded or written form, and to provide the results of all testing and examinations that had been conducted in the case. So that order was entered by Judge Stevens on June the 22nd. Mr. Nifong did not comply. He did not ever provide any witness statement from Dr. Meehan or any memorialization of an oral statement from Dr. Meehan, and he didn't ever provide all of the test results. He had turned over the report that Dr. Meehan had prepared, but it only contained the 3 matches. It didn't contain the information about the unidentified DNA from the multiple male contributors. There was another hearing. The defendants filed more motions to compel. There was another hearing, September the 22nd, and this one was before Judge Smith, Osmond Smith. And in response to a direct question from Judge Smith, Mr. Nifong said that Meehan made no other statements to him in any of their meetings beyond the contents of DSI's written report, and that DSI's written report encompassed the results of all tests performed by DSI. At that September the 22nd hearing, the defense counsel said, I want to make it perfectly clear what we're asking for. We have received no evidence to indicate that any testing has revealed the presence of DNA from men other than the people who gave samples for comparison purposes. If there are men if there's DNA from men on any of these evidence items who are not members of the lacrosse team and who are not the 3 men with whom Ms. Mangum acknowledges having consensual sex during the week or so leading up to this event, we want to know about it. They said that in open court on the record. Mr. Nifong did not respond to that in any way. What they were saying is it's not in the report, but if it exists, we'd like to have it, and he did not respond in any way. At the end of that hearing, Judge Smith entered an order. He ordered Mr. Nifong to by October the 20th to provide the complete file and underlying data of all DSI's testing. And the order expressly states, the court accepted Mr. Nifong's representations that Dr. Meehan said nothing during those meetings beyond what was encompassed in the final report of DNN Security, dated May 12th. The court therefore held that no additional discoverable statements by Dr. Meehan existed for the state to produce. After the September the 22nd hearing, Mr. Nifong still did not turn over any evidence of the DNA from these multiple unidentified males. He was required to turn over the underlying data for DSI on October the 20th, but did not do so. And he was prompted by defense counsel and finally turned that information over on October the 27th. As soon as he received it, Bradley Bannon, one of the attorneys representing David Evans, took the 1,844 pages of underlying scientific data and started to study it. And he's not a DNA expert, but he went to school and he studied this paperwork and he tried to figure out what all this meant. But he didn't find the answer until after the general election.